A court case is about to be decided that could determine whether you need government permission to buy a box of bullets. And if this case goes the wrong way, ammunition background checks could spread from California to every blue state in America. We're talking New York, Illinois, Washington, Oregon, all of them watching and waiting to copy California's playbook. The case is called Rhode versus Bonta. The court is the Ninth Circuit Court of Appeals. And the date you need to circle on your calendar is March 23rd, 2026, because that's when oral arguments happen in what might be the most important Second Amendment case of the year. And if you live in California or any state that's considering ammo restrictions, this case is going to directly affect your ability to buy ammunition. Quick question before we continue. Are you subscribed yet? Because what I am about to reveal could determine whether buying a box of 9mm requires a background check and a 3-day wait in your state. 90% of gun owners have no idea this case even exists. Hit that subscribe button right now so you never miss updates on cases like this that could change everything. Here's what's happening right now. California has a law that requires you to pass a background check every single time you buy ammunition. Not just when you buy a gun, every time you buy ammo. You walk into a store. You want to buy a box of 50 rounds of 9mm, the dealer has to run your information through California's database. If you pass, you can buy the ammo, but you have to pay a $1 background check fee. And you have to wait while the system processes. If the system is down, you don't get ammo. If there's a glitch in the database, you don't get ammo. If your name matches someone who's prohibited, even if it's not actually you, you don't get ammo. Gun rights groups sued California, arguing that this law violates the Second Amendment. The case is Rhode versus Bonta. Bonta is the California Attorney General. Rhode is Kim Rhode, an Olympic gold medalist in shooting sports. She and other plaintiffs argued that the right to keep and bear arms necessarily includes the right to buy ammunition. You can't exercise your Second Amendment right without ammo, so requiring a background check every time you buy ammo is an unconstitutional burden on that right. The case went to federal district court first. The judge sided with California. Then it went to a 3-judge panel at the Ninth Circuit. That panel also sided with California in a 2-to-1 decision. But then the plaintiffs asked for what's called an en banc review. That means the entire Ninth Circuit, all the active judges, will rehear the case. And the court agreed. That's huge. En banc reviews are rare. The court only grants them when the case involves a question of exceptional importance. And they scheduled oral arguments for March 23rd, 2026. Now here's why this matters so much. If the Ninth Circuit upholds California's ammunition background check law, that sets a precedent for the entire Ninth Circuit, which covers California, Oregon, Washington, Arizona, Nevada, Idaho, Montana, Alaska, and Hawaii. Every state in that circuit will know that ammo background checks are legally permissible. And the anti-gun states in that circuit will start passing their own versions. Oregon's already talking about it. Washington's talking about it. And beyond the Ninth Circuit, states like New York, Illinois, and New Jersey are watching closely. If California's law survives this challenge, they'll copy it. We'll see ammunition background checks spread across the country. But if the Ninth Circuit strikes down the law, it's a massive win for gun rights. It sends a message that you cannot burden the purchase of ammunition the same way you burden the purchase of firearms. It protects the Second Amendment in a meaningful way. Let me break down what California's law actually does, because the details matter. Under California Penal Code, Section 33(7)(d), if you want to buy ammunition, the seller must verify that you're not a prohibited person. The seller does this by checking your information against the automated firearms system, California's gun registry. If you're in the system as a registered gun owner, the check is supposed to be instant and costs $1. But if you're not in the system, maybe you moved to California from another state, or you inherited guns, or you just haven't bought a gun in California, then the seller has to submit your info to the Department of Justice for what is called a standard ammo eligibility check. That process takes longer and costs $19. And here's the kicker. Even if you pass the background check for a gun purchase, you still have to pass a separate check every time you buy ammo. Now here's what most people don't realize about how this law works in practice. The system fails all the time. I'm not exaggerating. There are documented cases of people being denied ammunition purchases because of database errors. Someone with a similar name is prohibited, and the system flags you. Or the system shows you as having a mental health hold from 20 years ago that was supposed to be expunged, but it's still in the database. Or the system just glitches and says no without any explanation. And when that happens, you can't buy ammo. You have to file an appeal with the Department of Justice, which can take weeks or months. In the meantime, you're unable to buy ammunition even though you've done nothing wrong. Let me give you a real-world example. Imagine a guy named Steve. Steve lives in California. He's a gun owner. He's never been convicted of a crime. He goes to the range once a month. One day, he goes to buy a box of ammo. The dealer runs the background check. The system denies him. Steve is confused. He asks why. The dealer doesn't know. The system just says denied. Steve has to go home without ammo. He files an appeal with the DOJ. 3 weeks later, he gets a letter saying there was an error in the database. Someone with a similar name and birth date has a felony conviction. The system flagged Steve by mistake. The DOJ clears it up, but Steve lost 3 weeks. He couldn't buy ammo. He couldn't go to the range. He couldn't practice. All because of a database error. And this happens to people all the time in California. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the 3 Supreme Court cases that could reshape gun rights in 2026. One of them involves the definition of a machine gun, and the outcome could legalize millions of firearms overnight. Subscribe right now so you don't miss it. Now let's talk about the constitutional argument, because this is what the court is going to decide. The plaintiffs in Rhode versus Bonta are arguing that the Second Amendment protects not just the right to own guns, but also the right to acquire guns and the ammunition necessary to use them. They cite Supreme Court precedent. In District of Columbia versus Heller, the Supreme Court said the Second Amendment protects the right to keep and bear arms for self-defense. But you can't defend yourself with an empty gun. You need ammunition. Therefore, the right to bear arms includes the right to obtain ammunition. And imposing a background check every time you buy ammo is a burden on that right. The plaintiffs also argue that California's law fails the historical test set by the Supreme Court in New York State Rifle and Pistol Association versus Bruin. Bruin said that gun regulations have to be consistent with the nation's historical tradition of firearm regulation. The plaintiffs say there's no historical tradition of requiring a background check to buy ammunition. In fact, for most of American history, you could buy ammo anywhere without any restrictions. You could order it through the mail, you could buy it at a hardware store. No questions asked. So California's law has no historical analog, and therefore it's unconstitutional under Bruin. That's the argument the plaintiffs are making. And if the Ninth Circuit agrees, the law gets struck down. But here's California's counterargument. The state says that ammunition regulations are permissible because dangerous people shouldn't have access to ammunition. The state argues that even if you have a right to own guns, the government can regulate the commercial sale of ammunition to ensure it does not end up in the hands of prohibited persons. The state also argues that the background check is a minimal burden. It only costs $1 if you're in the system, and it's usually instant, so it's not a significant infringement on your rights. And the state says there is historical precedent for regulating ammunition. They point to colonial era laws that regulated the storage of gunpowder because it was dangerous. They argue that if governments could regulate gunpowder, they can regulate ammunition. Now, gun rights advocates say that's a ridiculous comparison. Regulating the storage of gunpowder to prevent explosions is not the same as requiring a background check to buy ammunition, but that's the argument California is making. Now here's why this case is so critical beyond just California. If the Ninth Circuit upholds the law, other states will follow. New York already has some ammunition restrictions. Illinois has talked about it. Oregon and Washington are considering it. If California's law is upheld, those states will pass their own versions. And here's what that means for gun owners. Every time you want to buy ammunition, you'll have to pass a background check. You'll have to pay a fee. You'll have to wait. And if there's any issue with the system, you'll be denied. This creates a massive barrier to exercising your Second Amendment rights. Some people say, well, just stock up on ammo now, buy a bunch before the laws spread. But that's not a solution. Ammunition degrades over time, and not everyone can afford to buy thousands of rounds at once. Most people buy ammo as they need it. A box here, a box there. And if every purchase requires a background check and a fee, it adds up fast. Let me give you another example. Imagine a single mother named Lisa. Lisa lives in a state that adopted California's ammo background check law. She owns a handgun for home defense. She goes to the range twice a year to practice. Every time she goes, she buys a box of 50 rounds. Under the new law, she has to pass a background check every time. That's a $1 fee per visit, plus the time waiting for the check. One visit, the system is down. The dealer can't run the check. Lisa can't buy ammo. She can't practice. She drives home. That's gas wasted, time wasted. Another visit, the system flags her because there's a Lisa Johnson in the database with a criminal record. Lisa has to file an appeal. It takes 3 weeks. She misses her range day. These aren't hypothetical problems. This is happening in California right now, and if the Ninth Circuit upholds the law, it'll happen in more states. Now, quick legal note. This is educational information, not legal advice. If you're affected by ammunition laws, or if you want to support legal challenges to these laws, consult with an attorney or donate to organizations like the Firearms Policy Coalition or Second Amendment Foundation that are fighting these cases. Now, let's talk about what happens at oral arguments on March 23rd. Each side gets time to present their case to the full Ninth Circuit panel. The judges will ask questions, they'll push back on arguments, and then they'll deliberate and issue a ruling, probably a few months later. Here's what to watch for. If the judges focus on the historical test from Bruin, that's good for the plaintiffs, because there's no historical tradition of ammo background checks. But If the judges focus on balancing public safety against individual rights, that's bad for the plaintiffs, because California will argue the law is a reasonable safety measure. Another thing to watch for is whether the judges distinguish between buying guns and buying ammo. If the judges say ammunition is different from firearms and can be regulated more heavily, that's bad for gun rights. But if the judges say ammunition is essential to the exercise of the Second Amendment and deserves the same protection as guns, that's good. And here's what I'm predicting. This is going to be a close decision. The Ninth Circuit is not a gun-friendly court. But after Bruin, even liberal judges have to take the Second Amendment seriously. I think we'll see a split decision. Some judges will vote to strike down the law, others will vote to uphold it, and it'll come down to a few swing votes. If I had to guess, I'd say the law gets upheld by a narrow margin, but I hope I'm wrong. Because if the law is upheld, it's going to spread. And gun owners across the country will face ammunition background checks. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these critical legal updates first. Click that subscribe button right now because the cases I am covering next week could affect your ability to own certain firearms after the Supreme Court rules in June. Don't miss it. Now let's talk about what you can do right now. First, stay informed. Follow this case. Check for updates after oral arguments on March 23rd. I'll be covering it on this channel, so make sure you're subscribed. Second, if you live in California, document any issues you have with the ammunition background check system. If you get denied incorrectly, if the system is down, if you face delays, keep records. That evidence can be used in future legal challenges. Third, support the organizations fighting this case. Donate to FPC, SAF, CRPA, or other groups involved in the lawsuit. These cases are expensive and they need funding. Fourth, contact your representatives. If you live in a state that's considering ammunition background checks, let your state legislators know you oppose it. Make your voice heard. And fifth, if you're in California and you can, stock up on ammunition while you can still buy it. I'm not saying hoard thousands of rounds, but having a reasonable supply means you're not dependent on a system that fails regularly. Now let me address the other side's argument because I want to be fair. Supporters of California's law say it's a common sense safety measure. They argue that prohibited persons shouldn't be able to buy ammunition, and a background check ensures they can't. They point to cases where criminals bought ammo and used it in crimes. And they say, if we had ammo background checks everywhere, that wouldn't happen. Here's my response to that. We already have laws against prohibited persons possessing firearms or ammunition. If someone is prohibited, they're breaking the law by having ammo. Adding a background check doesn't stop criminals. It just burdens law-abiding people. Criminals don't buy ammo at gun stores where they have to pass a background check. They buy it on the black market. They steal it. They get it from someone else. The background check only affects people who are following the law. And for those people, it's an unnecessary burden that doesn't make anyone safer. Now let's talk about what happens if the Ninth Circuit strikes down the law. That would be a huge victory. It would mean California can't require background checks for ammunition purchases. Gun owners in California would be able to buy ammo without going through the database. The $1 fee goes away, the delays go away, the denials due to database errors go away. It would also send a message to other states. Don't try this. It's unconstitutional. And it would give ammunition to future legal challenges in other states that already have ammo restrictions. But here's the problem. Even if the Ninth Circuit strikes down the law, California will probably appeal to the Supreme Court. And the Supreme Court might take the case. That means this fight could go on for another year or two. And in the meantime, California might try to rewrite the law in a way that passes constitutional muster. They might reduce the fee. They might improve the database. They might add exceptions. And then we're back to square one, fighting a new version of the law. This is the game anti-gun states play. They pass a law. It gets struck down. They tweak it and pass it again. And gun rights groups have to keep fighting in court, spending money and time, while gun owners deal with the restrictions. Now, let me give you a timeline of what to expect. March 23rd, oral arguments happen. Probably sometime in June or July, the Ninth Circuit issues a ruling. If they strike down the law, California appeals to the Supreme Court. The Supreme Court decides whether to take the case, probably by October. If they take it, oral arguments would be in early 2027, with a ruling by June 2027. If they don't take it, the Ninth Circuit's ruling stands, and the law is either upheld or struck down permanently. This information could literally determine whether you can buy ammunition without government permission in the next few years. Subscribe now, because I'll be covering every update in this case as it happens. Hit that subscribe button so you don't miss the ruling when it drops. Look, I spend hours every week following cases like this, reading court filings, and breaking down what it means for gun owners so you don't have to. The least you can do is hit that subscribe button to support this channel and make sure you never miss a case that could change your rights. Subscribe right now. And if you found this helpful, share it with every gun owner you know, because most of them have no idea this case is happening or what's at stake. Remember, this is educational information based on the Rhode versus Bonta case and Second Amendment law. It is not legal advice for your specific situation. Always consult with a qualified attorney if you have legal questions. Stay informed, stay engaged, and watch what happens on March 23rd. This case could change everything.